A very good day to Mr. Lai. My name is Christopher, and today I will be explaining the customary international law and its importance. Customary international law originates from a general practice accepted as law. In the Asylum Case 1950, customary international law is defined as a constant and uniform usage, accepted as law. Because customary international law permits international law to develop directly from the behavior of the states, it is ideally suited to the decentralized structure of the international legal system. Official accounts of military operations and a range of other official documents, which includes military manuals, case law, and national legislation, reflects that a general practice accepted as law. Customary international law is implied in the concept of principles and the rules of international law. It is stated in Article 21 sub 1 sub b that outlines the application of the law in the International Criminal Court. There are two elements to customary international law, which includes consistent and general international practice by states and by opinion jurists. We'll start with state practice. Any state activity can constitute state practice for the purpose of creating customary international law. It is referred to as the material content of customary international law. This includes official public statements, physical actions, diplomatic correspondence, treaty making, national legislation, and the conduct of states in international governmental organizations. In the case of Nicaragua against the United States, the court did not consider the need that the corresponding practice be in strict compliance with the norm for the rule to be customary. In the construction of war case, the International Court also mentioned that decisions passed by the General Assembly and the UN Security Council might serve as proof of existence of law and principles. In some cases, local laws of the state may serve as the foundation for customary practices. In the Scotia case, which the US Supreme Court determined in 1871, a British ship sank an American ship at sea. The court determined that because other states had passed laws in essentially comparable terms, the British navigational process created by a parliamentary act served as the foundation for the relevant international custom. A rule on opinion juris cannot be established without state practice. The court stated in the advisory opinion on the use of nuclear weapon case. Now, in the asylum case, the court ruled that the customary rule had to be in line with a consistent and uniform use followed by relevant states. Yet, it is a crucial requirement of customary international law, although there is no set time limit in international law. Instead, it depends on the specific of the case and the type of usage in question. This can be seen in the case of North Sea continental shelf case, whereby it was held that the length of time to establish customary international law differ from subject to subject. Now we'll move on to opinion juris. The key definition of opinion juris is that it is necessary that states believe that they are under a legal obligation to follow a particular practice. Opinion juris is a psychological element. It is the belief that the state activity legally obligated as distinguished from motives of fairness, convenience, or morality. In the key case of North Sea continental shelf, 1969, according to the ICJ, there must be a proof of conviction that this conduct is rendered compulsory by the presence of rule of law, mandating it for the customary international law to emerge. The states concerned must therefore feel that they are conforming to what amounts to a legal obligation. Because it is hard to discern between behaviors that results from custom, politeness, and those that states are legally required to follow. It is crucial that state practice be recognized as law. States are artificial legal persons there are true national governments that rarely make the intentions clear. In this case, it will be reviewed by the instruments of IGOs whether states in general consider themselves under obligation to behave in a certain way. A case to illustrate this is the case of Nicaragua, 1986. It was decided by the ICJ that the provisions of the UN Declaration on the Principles of International Law concerning friendly relations could be used to satisfy the opinio juris required to support the existence of a customary international law rule concerning the prohibition on the use of force. Now we move on to the persistent objector rule. According to the persistent objector rule, a state will not be bound by a specific customary international law rule if it objects to it from the moment the rule is formed and continues to do so. In the 1951 International Courts of Justice case, Anglo-Norwegian Fisheries case, United Kingdom argued against Norway's adoption of the straight baseline approach to determine the size of its territorial sea. It said that a 10-mile shutting line for bays was a customary international rule that had long been in place. Due to its customs, Norway claimed a territorial sea that was significantly bigger than that of other states. The argument made by the United Kingdom was denied by the International Courts of Justice in light of the persistent objector. In any case, the rule will appear to be inapplicable as against Norway, since she has consistently resisted attempts to apply it to the Norwegian shore, according to the rule. Now, we'll move on to the importance of customary international law. The other international humanitarian law accords have not received the same level of universal ratification as the four 1949 Geneva Conventions. Certain protections left out by treaty law for armed conflict victims are filled in by customary international humanitarian law. These gaps arise from either the failure to ratify the pertinent treaties or the absence of specific provisions governing non-international armed conflicts under treaty law. The benefit of customary law is that it does not require official acceptance for a state to be bound by a rule, if the general state practice upon which the rule is based is widespread, representative, and practically consistent, and recognized as law. The study helps to enable better understanding of the relevant laws since it identifies the customary international humanitarian law principles. Greater adherence to the law is ensured when those who must follow it are aware of the laws. International humanitarian law makes it possible to guarantee the protection of people impacted by armed conflict due to combined effect of legal awareness and the presence of potential consequences, particularly those imposed by national and international tribunals. International law is generally intended to govern the interactions between states, and as a result, it is binding on all states. This is also true of treaty-based or customary international humanitarian law, which governs military conflicts between states. However, a unique aspect of international humanitarian law is that certain of its standards govern armed confrontations that take place between such organizations or between a state and an armed opposition group. All sides, whether a state or an armed opposition organization, must abide by the laws that govern such confrontations. The examination of state practice reveals that several provisions of customary international humanitarian law that apply to armed conflicts involving the parties have binding effect on both states and armed opposition organizations. The International Committee of Red Cross identified 161 customary standards that are relevant in both international and domestic armed conflicts. In research that was published in 2005 by the University of Cambridge in Customary International Humanitarian Law. Although they were not codified, these laws already existed and were obeyed by many different countries. This demonstrates that there is mutual understanding both inside and across nations. According to the study, governments have already determined where to draw a boundary for humanitarian reasons, and they typically do not violate such borders even during armed conflict, even in the absence of the Geneva or Hague Conventions. To conclude this, the constitutive elements of customary international law specify the legal traditions from which the international courts of justice and other tribunals draw their authority. Some of the choices that some nations made in its international sphere are justified by these legal sources. Some controversial decisions may be justified in the International Court of Justice as long as they are based on any of the elements of customary international law. Well, thank you. That's all for my presentation.